Hi, thanks for watching. I'm speaking to you as someone who supports the Second Amendment, and I want to be blunt. Duncan v. Bonta may be the most important firearms case in years. It challenges California's ban on detachable magazines that hold more than 10 rounds, and the petition was docketed at the U.S. Supreme Court as number 25-198 on August 19, 2025. supremecourt.gov. I'm going to do three things in this video. First, I'll give you the procedural history and explain why the case landed at the Supreme Court. Second, I'll walk you through the engineering and design of magazines so you understand why a numerical cutoff, like 10 rounds, is a technical, not a mechanical distinction. Third, I'll analyze the state's legal arguments and the plaintiff's responses, including the Fifth Amendment takings claim that sits beside the Second Amendment challenge. I support lawful firearm ownership, and I'm skeptical of rules that single out technical components. I'll nonetheless stick to facts as I lay out mechanics, law, and likely outcomes. I'll be precise and focus on what matters. Part 1. Procedural history and stakes. The simplest way to start is with the timeline. The earliest modern challenges to California's limit date back several years and travel through multiple courts. In district court, Judge Roger T. Benitez issued rulings that found the statute unconstitutional. Those rulings were appealed, reversed, and re-litigated in light of the Supreme Court's 2022 decision in Bruen. After remand and further proceedings, the Ninth Circuit reheard the case en banc and issued an opinion on March 20, 2025, upholding California's statutory restriction, cdn.ca9.uscourts.gov. Because the Ninth Circuit's ruling came en banc, the plaintiffs petitioned the Supreme Court for review. The petition was docketed as number 25-198 on August 19, 2025. Multiple amici, including state attorneys general and national firearms organizations, filed briefs supporting review or urging particular holdings. On the other side, public safety advocacy groups and the state filed responsive briefs explaining why the court should leave the Ninth Circuit's ruling in place. The dynamics are those of any high-stakes constitutional fight: technical briefing, heavy amicus participation, and an eye toward uniform national rules. Why does this matter? If the Supreme Court grants review and rules that bans on certain magazines violate the Second Amendment as interpreted under Bruen, states with similar statutes could face immediate constitutional vulnerability. Conversely, if the court denies review or upholds the Ninth Circuit, those bans remain enforceable in that circuit and could be persuasive elsewhere. Either way, this case shapes the national conversation about how the Constitution protects modern firearm access and what counts as an arm or a permissible regulation in the 21st century. That procedural posture is important because Bruen set a new test focusing on textual coverage and historical tradition. Under Bruen, once the challenger shows the Second Amendment's plain text covers the conduct, the government must point to historical analogs that justify the modern regulation. That doctrinal framework animates many of the briefs here and moves the dispute from policy fights into historical and technical comparison. Part 2. Engineering and design of magazines. If you want to argue about magazines intelligently, you have to understand what they are. A detachable box magazine is an assembly that stores cartridges and feeds them into the firearms chamber. Its primary components are the magazine body or shell, the follower that bears on the top cartridge, the spring that pushes the follower, the feed lips that present the top round to the bolt or slide, and a base plate that secures everything. Those parts are simple, but their interaction is precise. Small changes in follower geometry, spring rate, or feed lip shape materially affect feeding reliability. Good magazine design is about predictability and tolerance control. There are common commercial families of magazines that illustrate how capacity is a design choice. AR-15 pattern magazines, often called STANAG type by users, commonly come in 30-round versions and fit a broad set of rifles. Glock pistols use magazine families with capacities that vary by model and by extended configuration. Some Glock magazines are available in standard 10 or 15-round versions, others in 17, 19, or even 33-round capacities. Those examples show that manufacturers intentionally produce multiple capacities to meet ergonomics, legal limits, and market demand. The geometry of the magazine determines capacity.
A single-stack magazine aligns rounds in a single column. That design minimizes width but limits rounds per unit length. A double-stack magazine staggers cartridges, so you get more rounds in the same or similar length at the cost of a wider grip and slightly different feeding dynamics. Engineers describe those trade-offs in terms of ergonomics, balance, and center of gravity. A long 30-round magazine will change how a rifle handles and how much the shooter must resist muzzle rise. Designers accept those trade-offs to optimize reliability and controllability. Different materials matter. Steel magazines have a long history of resilience under repeated loading. Polymer magazines are lighter, can be molded into complex shapes, and sometimes incorporate viewing windows or anti-tilt follower features. Drum magazines store rounds in a coiled or stacked spool that allows very high capacities, but drums are mechanically more complex and often less reliable under harsh conditions. Thus, a 70-round drum is not the same mechanical animal as a 20-round box magazine. Lumping them together at a single numerical cutoff ignores meaningful differences in reliability and operation. Manufacturers also tune follower geometry and spring rates to reduce tilt and to maintain reliable upward pressure as cartridges are expended. Feed lips are often heat-treated or reinforced to preserve alignment. Small deformations in feed lips can lead to misfeeds. Spring metallurgy influences fatigue life. A poorly tempered spring will sag and reduce reliability long before the magazine reaches an arbitrary legal lifespan. These small engineering choices make a difference for competition shooters and for law-abiding citizens who expect reliable function. There is also a cultural and commercial dimension. Magazines are standardized for interoperability because militaries, manufacturers, and accessory markets favor predictable interfaces. That modularity explains why regulating magazines by capacity has ripple effects across many firearm platforms and user communities. In short, magazine capacity is embedded in a matrix of physical design, human ergonomics, and market standardization. Treating it as a mere number in statute collapses that complexity.
Finally, reliability and function are central to legal analysis. A magazine that jams can render a firearm unusable. A magazine that feeds reliably makes the firearm operate as designed. Courts assessing whether a magazine is an arm in the constitutional sense should pay attention to those mechanical facts. Magazines are not decoration, and their engineering enables the weapon's intended performance. Part 3. Capacity, Tactics, and the Empirical Debate. Opponents of high-capacity magazines point to mass casualty incidents and argue that more rounds between reloads increases the potential for fatalities. That observation is straightforward. More carried rounds can increase opportunity. But causal public policy claims require careful empirical analysis. Some research suggests that certain restrictions correlate with modest changes in some outcomes. Other studies show ambiguous or no measurable effect when you control for many confounding variables. Policy choices should be informed by careful, transparent evidence rather than headline correlation alone. From a tactical point of view, reloading is not an absolute limiter. A shooter who must reload still has options. They can carry multiple compliant magazines, carry extended magazines that meet the letter but not the spirit of a law, or switch to platforms that offer similar total capacity in multiple magazines. Simple numerical restrictions therefore reduce certain kinds of continuous, uninterrupted firing, but do not eliminate risk for determined attackers who plan and practice. A legal and practical point follows. Legislation that focuses only on capacity assumes a nexus between magazine size and public safety outcomes that courts must evaluate carefully under Bruen and related doctrines. Treating magazines as mere accessories obscures how they integrate with firearms and lawful uses, home defense, competition, and training. If the state wants to justify categorical capacity limits, it needs to articulate either adequate historical analogs or compelling empirical evidence that the restriction fits the problem. There is also the point that many mass shooters select weapons and tactics based on availability and personal preference, not necessarily on an optimal engineering selection. Some attackers used rifles with standard capacity magazines, others used handguns with multiple reloads. The presence or absence of a single large magazine rarely tells the whole story. Consequently, policy must be precise, means that demonstrably cause harm without creating overly broad prohibitions that sweep in lawful uses and lawful owners. Finally, enforcement matters. Laws that are difficult to enforce uniformly produce uneven outcomes across communities, and that unevenness can exacerbate perceptions of unfairness and undermine compliance. If the policy goal is fewer casualties, lawmakers should combine technical regulations with investments in enforcement resources, training, and community violence intervention strategies rather than relying solely on a single numeric cutoff. Part 4. Legal Analysis, Ninth Circuit, Bruen, and the Takings Claim. The Ninth Circuit's en banc opinion treated magazines in two alternative ways, either outside the core of the Second Amendment's text or, if within the text, justifiable under a historical tradition analysis. That decision was issued on March 20, 2025.
The court attempted to reconcile modern magazine regulation with Bruen's requirement that the government identify historical analogs that meaningfully correspond to the burden imposed by the modern law. Under Bruen, once a challenger shows the Second Amendment's plain text covers the conduct, the government must demonstrate that the regulation is consistent with the nation's historical tradition of firearm regulation. That pushes litigation into granular historical inquiry and invites vigorous disagreement. The Ninth Circuit concluded that the government's historical materials were sufficient or that magazines could be characterized as regulatory adjuncts rather than core arms, conclusions that reasonable judges can dispute. In addition to the Second Amendment claim, the plaintiffs pressed a Fifth Amendment takings argument because California's statutory regime in some instances requires surrender, destruction, or permanent modification of property. When a state forcibly removes property without paying just compensation, that raises classic takings concerns, distinct but complementary to constitutional text debates. The takings claim complicates the case and provides an independent ground for relief in some factual circumstances. California filed a brief in opposition to the petition for certiorari, urging the Supreme Court to deny review. That brief was filed as part of the cert stage docket in October 2025. The state emphasizes public safety interests and asked the court to let the circuits continue to develop the law. But the combination of circuit disagreement and robust amicus participation, including filings from national Second Amendment organizations and multiple state attorneys general, increases the likelihood the court may want to offer clarity. Part 5. Consequences, remedies, and what you can do. If the Supreme Court grants review and rules broadly for the plaintiffs, many state magazine bans would be vulnerable and some laws could be struck. That outcome could restore the rights of many lawful owners, and it would likely provoke state-level responses as legislatures respond to a new constitutional pronouncement. Courts sometimes craft narrow holdings limited to specific statutes and records, so outcomes can vary in scope. If the court declines review or upholds the Ninth Circuit, the regulatory status quo persists in that circuit and similar statutes remain enforceable. Either scenario shows a practical truth. Constitutional doctrine moves slowly, and durable protection of rights often requires patient, technical litigation and careful record building. To be constructive, consider these steps right now. Follow the Supreme Court docket for number 25-198 and read the public filings. Petitions, responses, and amicus briefs explain the leading arguments and evidence. Support civil litigation organizations that pursue constitutional claims if you want to contribute. If you own magazines in a jurisdiction with a ban, document purchases, keep receipts, and consult counsel about compliance options. Lawful conduct and careful records protect you. There are also policy alternatives that carry less constitutional friction: voluntary buybacks with fair compensation, targeted enforcement against criminal misuse, funding for safety,
Training and safe storage programs, and investment in violence prevention initiatives. Those measures can reduce harm without forcing a legal debate over whether a number like 10 is a constitutional dividing line. This is a technical constitutional fight. Informed public debate helps craft lawful, effective solutions. I'll wrap up with a short summary. Duncan v. Bonta sits at the intersection of modern engineering and constitutional text. At stake is whether states may single out detachable magazines by numerical capacity and demand their destruction or surrender. The Supreme Court docket for the case is number 25198, and the en banc Ninth Circuit issued its pivotal opinion on March 20, 2025, supremecourt.gov. My bottom line is this: magazines are mechanical modules that materially affect how an arm functions. A flat rule that treats vastly different magazine architectures the same, ignores engineering realities, and risks legal error if courts accept the claim that a number alone separates lawfulness from illegality. That is not a statement against sensible safety policy. It's a plea for legal reasoning grounded in technical fact and constitutional text. Stay informed, follow the docket, read briefs, and support lawful litigation. Learn the technical details so debate rests on facts, not slogans. Subscribe if you want full breakdowns of the major briefs as they arrive, and leave a thoughtful comment below. I read them, and I will respond to the most useful observations. Expect more detailed breakdowns soon. Thank you for watching today.